My Florida parents added sis and I to their paid off home deed. What happens when they pass? So you're added to the deed while your parents are still alive. This can play out in different scenarios, sort of depending how the deed is worded. I'm assuming most likely they added you as what's called joint tenants with rights of survivorship. So this is typically what's done when you want property to pass to the surviving title holders. So if you're joint tenants with rights of survivorship, when one of the owners passes away, the other owners will continue to own the property equally. When another one passes away, the other two, say your sister and you, would own the property equally, and then it would go the same when one of either you or your sister passes away, then the survivor ends up with the property. So owning something jointly or as joint tenants, if it's a real property, does to some degree prevent probate, and ultimately in the end a probate is needed when you have one surviving owner. Now, if the deed doesn't specify that, if it doesn't say joint tenants on it or joint tenants with the right of survivorship, then you're considered what's called tenants in common, which means you each own an undivided interest in the property. So this would mean that the property wouldn't just automatically pass to you and your sister. If you're tenants in common, and again, this occurs if the deed is just silent, if it doesn't say joint tenants or tenants in common, if it doesn't say anything at all, it just lists you all as owners, well, then it's tenants in common. Or especially, of course, if it says tenants in common, then you're taking the property as an owner with an undivided interest in the property. What that means is if there's 4 of you on the deed, you each essentially own 1/4 of the property, and the 1/4 that any of the owners own has to go through probate upon that owner's passing, or when they die, their 1/4 goes to probate. So when you have this tenants in common or nothing at all indicated on the deed, there's going to be the need for 4 probates essentially. When each owner passes away, their share goes to probate. Now the other issue, and why we don't recommend doing this as an estate planning tool, by doing this I mean just adding your kids to the deed while you're alive, is what can oftentimes be the bigger issue, even if you have the joint tenants right on the deed, and ultimately you end up with the property when both of your parents pass away. If the goal here is to sell the property, if you and your sister aren't planning on living in the property, and if neither of you live in the property now, so it's not considered your primary residence, when you end up selling the property, you will have to pay taxes on the sale that are much higher than if you inherited the property. In fact, if you inherited it by not being on the deed. So if you inherited it through a probate, or because it was in a trust, or in Florida through a ladybird deed, you actually get to use the value of what the property was when your last parent passed away as the value that you use to figure out taxes when you sell it. So you inherit it, it's worth $700,000. You sell it within the year, it's still worth roughly around $700,000, no capital gains. Flip that, your parents put you on the deed while they're still alive, so you're not inheriting it either through probate or through a trust or through a ladybird deed, you're actually on the deed while they're alive. Well, then you have to use the number that they bought the property for, the purchase price, as your tax number to figure out capital gains tax. So if they bought the property when it was $200,000 and now it's worth $700,000, and you turn around and sell it for $700,000, you're paying capital gains on the difference between the two and the $700,000 or $500,000. So that can be a big reason to not just add your children to a deed, because that's a pretty big tax disadvantage when you're looking at just turning around and selling the property. We've actually redone deeds like this for some of our clients, where we take them off the deed and then we do a ladybird deed, or we have the property put in trust and have the kids inherit it that way, only because the tax burden is going to typically be much, much less. So to answer the question, ultimately, if the deed is worded right, yes, if it's joint tenants, you will essentially inherit the property or get the property when your parents pass away. However, you might have a heavy tax bill when you turn around and sell the property, versus if this property is in a trust or a ladybird deed where you aren't on the deed during your lifetime, but you inherit it after your parents pass away, and then you turn around and sell the property. You're most likely not going to have capital gains tax, or it'll be very, very minimal. Hope this helps. If there's any other questions like this, or anything to do with estate planning, elder law, asset protection, and you are in Florida, please contact my law office. The link is in the bio.